Before we bring in our jury this morning, yesterday the court had reserved on a Richardson hearing regarding Exhibit 2 as identified in the defendant's fifth amended reciprocal discovery exhibit list, specifically 119 pages of records from Advent Health Winter Park that were provided to the state yesterday morning by way of USB drive. Yesterday the court had ordered that the defense was to provide an edited version of only the records pertaining to anxiety and the lack thereof, or anything pertaining to those matters, but before 9 a.m. this morning. Was that done, Mr. Owens?
Yes.
Okay. Mr. J, have you had the opportunity to review the culled down list of 119 documents?
Yes, sir.
Okay. What is remaining of those 119 specific JPEG images, and what do they pertain to?
Your Honor, most of them deal with just billings, observations by the medical personnel, so on, that don't necessarily apply to the issue of anxiety, as the court had indicated. I did include certain pages that discuss depression issues, as I believe that they were related to anxiety. And then I've identified 4 or 5 other pages that are not anxiety related that may be relevant to the case. I've described that.
Of those 119 images, how many are being sought? 15? Okay, thank you. State response.
Apparently, these are all just related to a January 23rd, 2018 admission at Advent Health Winter Park. So it appears they're not seeking to introduce any records from other instances that were contained in the records that were first disclosed to the state on September 27th.
You speak of the 81 pages?
Yes, sir.
Thank you.
Nor the new 119 pictures that's still not in a PDF form. So of the 15 pages, the first 2 that they list are pages 9 and 10 out of 111. And I believe I've identified them as best I can. However, the Bates stamp from the hospital is over other text, and there is no other Bates stamp. So I'm guessing that it's pages 9 and 10 out of 111. It appears to just be a health information sharing sheet, like a contract. I don't understand the relevance of those 2 pages. Pages 21, and then they skip 22. 23, 24, and 25 are all part of her initial assessment on 123.18. We don't object to those pages, but for, and I apologize that there's a but for, the fact that at the bottom of page 25 begins her toxicology screening, and that does go into page 26, and they did not indicate that they want to use page 26. However, without page 26, we are going to experience relevancy issues and a 403 objection from the state, and that is because in her toxicology screen, for which she is coming to the treatment to seek treatment for depression symptoms, she is at 165 for ethanol, meaning when converted, it's 0.165 grams per deciliter, over twice the legal limit. It's a central nervous system depressant. We are going to have at least one medical doctor, well, 2. The forensic pathologist will testify for the state, and then our expert on battered spouse syndrome, if we get to that point, is also a medical doctor. She's a psychiatrist, not a psychologist. Will tell us that ethanol is a central nervous system depressant. I believe even the psychologists will be able to get that information in. So we are objecting to pages 21 through 25 coming in without page 26.
If I understand your argument, is it a rule of completeness issue?
Yeah, I mean, in the sense that it applies to documents as opposed to statements. I mean, it is an out-of-court statement, so it is a rule of completeness issue, particularly when the symptoms and complaints of the patient on that particular day were crying and being depressed and showing signs of using a central nervous system depressant. The rest of the talk screen, pages 27 and 28, they did not list. We are not complaining that they are not including that. Page 29 is another page they listed. That's more of a narrative about her visit at January 23rd, 2018. We do not object. Page 43 is just her vital signs. We don't object. Page 44 is more of the initial assessment on this January 23rd, 2018 visit. We do not object, nor do we object to pages 45, 46, or 47.
What are pages 45, 46, and 47, just for my own?
More of this initial assessment of January 23rd, 2018 was my understanding.
Okay.
Page 48, we are asking again that this be included. Again, I don't believe it's super mysterious why we are going from pages 43, 44, 45, 46, 47, and then skipping page 48, and then going to 49. But we do want page 48 included. On that page includes her height and weight at the time. Page 63.
What's 49? So seemingly that's included.
49 is just some results. Again, it's misleading and doesn't provide full context without what I've described as page 26, because part of the results on page 49 show that she was
Bless you.
tested for the presence of ethyl alcohol or ethanol, but it doesn't give the results.
Are the results contained in another page?
Just on page 26, the one I previously described as wanting included.
So not following 49 to 50 or 51 sequentially?
No, because the pages they want from the 40s are 43 through 47, skipping 48, and we're asking for 48 to be included between 47 and 49 to make sure it's relevant and complete.
But they are also seeking 49, correct?
Yes.
Thank you.
They just skipped 48, just like they skipped 26.
Okay.
Page 63, it appears to be repetitive, but we don't have any particular objection to page 63 of the 111. Page 108 seems to be another part of the initial assessment from January 23rd, 2018, so we don't object to that. So basically, we're asking for pages 26 and 48 to be included.
Okay, thank you. The the state did seek a Richardson hearing yesterday in this matter, and based on binding precedent by the 6th District Court of Appeal, Young v. State, 369 Southern 3rd, 1243, regardless of the culling down of the records, the court still is required to conduct a Richardson hearing. As to the issue of whether the defendant's violation was inadvertent or willful, Mr. Owens had advised that these documents were obtained sometime last week. He was unable to provide any specificity. He's going to confer with his office. Mr. Owens or Mr. Beck, are you in a position to advise when these documents were first requested, when they were received, and when they were sent to the state? Specifically, any documents pertaining to Exhibit 2, the Advent Health Winter Park records.
Judge, I did check with my secretary, Margaret, and my understanding is, I didn't know that was going to be a question about when we actually sent it out. I know it was one of my trips down here. I got Sarah Boone to sign a medical release. We sent it to the hospital. It took a couple of weeks, I want to say. We got it last week. We don't know exactly when. We don't timestamp at our office when something is mailed in, and it was mailed in from the hospital to my office. For whatever reason, the records did not get to Shelby, who was handling that issue, until late, and I think it was yesterday or the day before, that she was aware that they had not been disclosed. We provided the copy to the state at that time.
So did these records come in batches? Because my understanding, based on the state's representation and their objections, was that the first 81 pages came on September 27th. Those were provided.
Those were separate. Those were records that some of the other lawyers, one of the other lawyers had received, and we sent them on, but the problem was they had notes on them. So we sent that 81, but it wasn't directly from the hospital, so we were trying to get a more complete, unedited copy of the records. That's why we made our request.
Okay, and when was the error identified in time as to when these items were not sent, such that they were provided via USB yesterday?
Whatever date we gave them is when we realized there was an error, that same day.
Okay, my understanding that would have been yesterday morning.
Yes.
Okay. Anything else, sir?
If I may, real quickly, based on the invoice that was sent from the Winter Park Advance Building Department, apparently it's a subcontractor, the request was made on the 27th of September. I suspect they waited until they received confirmation of payment of $135 for the receipt of those, so we received those. So it's all been within a couple of weeks, plus we had the hurricane issue last week, and I think there were issues that has to do with the matter being provided for. I did speak with the state yesterday afternoon after I had a chance to look at the records, and I had some senses of these matters or relationship to, and was told that they already had those records and we reviewed them. So I don't think there's any records to the state based on our submissions.
Okay. Any further argument or positions with regard to the Richardson analysis, Mr. J?
That's for the purpose of this hearing, I'd like the stack of documents.
Is that the 119 pages, sir?
No, sir, it's the 81 pages that we got on September 27th, 2024.
Any objection? All right, what was pre-marked A for the purposes of the Richardson hearing will be received without objection as states 1.
Your Honor, there was just a reference that 81 pages were all marked up by the defense. There's no markings. The issue and the confusion that the state attorney's office still has, though, is page 68 of 81 of these original 81 documents.
If you have a cell phone on, they need to be silenced and turned off, please. If you cannot follow the court's instructions, due to the publicity in this case, I will ask for you to be removed. Does everyone understand? Thank you. You may proceed.
And I realize that I've only had a limited amount of time to review the 119 pages that came in yesterday. And again, it's more difficult to review those because it's not in a PDF where I can word search it and do any of the things that are afforded to us with modern technology. It came in as 119 separate JPEGs. They're not in order. So for instance, when I'm trying to look for page 43 of those 111 records out of the 119 pages, it's not in order. And I've done my absolute best to try and see if this page, which is 68.
Yes. And referring to 68 of the 81 that was
Yes, sir.
entered as one, correct?
Yes, sir. It is sub-labeled within these records as page 2 of 14, and it appears to be a part of her visit on January 23rd, 2018. And in the social history provided, it says alcohol use denies, tobacco use denies, and the other part isn't relevant. And I just haven't been able to find that, and so I'm asking for the leeway to continue to try and search for that particular page out of the 119 so that I may ask that out of the doctrine of completeness and fairness that it be included. I'm just, at this point, I have not been able to find anything in the records that says that, and I'm limited in my abilities to cheat with technology and put it, if there's a 119-page PDF and you make it word searchable, you just put in the magic word, and it helps the attorney greatly. So that's why there's this confusion, and that's part of why I had to raise this issue. Was just at my first glance at those pages yesterday, I knew that something seemed off compared to what was previously provided.
Okay. Any response?
It has a heading, Your Honor. I'm not familiar with that heading in the documents that I was reviewing. I'll look for it again and I'll provide
Okay.
information.
I appreciate y'all working together on that. So here's what we're going to do.
If I may.
Yes.
We had told the state that we would bring in a printed copy, not the PDF, this morning. But Federal Express, which is the block away, for whatever reason, the road was being constructed, so they closed, so we were there at 8 o'clock to get the copy to the state we had promised, but we will bring one at lunch to hand to state.
Okay. Appreciate it. All right. Any other argument with regard to the Richardson issue? Anything further, Mr. Beck? Okay. With regard to, let me conclude the Richardson analysis first. All right. Thank you both for your positions and your arguments. The court has, as a matter of law, the court needs to determine whether the defendant's violation was inadvertent or willful. Court finds that based on the positions provided by the defense that the disclosure was inadvertent, but I do find that the violation had some level of substantiality to it. But due to the state's review and the defense compliance with the court's order yesterday as to culling down to the pages that we've identified, the court finds that the violation had a limited ability on the state's ability to prepare for trial due to the lack of objections to the majority of the documents, with the exception of page 48 and 26, which are sought to be included. For those reasons, I find that the prejudicial effect of the substantial disclosure is limited, and I'm not going to order the defense, not going to prohibit the defense from proceeding forward on moving these items into evidence. However, I do want to address the 403 rule of completeness issue with regard to pages 26 and 49 26 and 48 as sought by the state. No objection, Mr. Beck. All right, thank you. So the state's request is granted. Pages 26 and 48 will be included in any evidentiary documents that are sought to be moved into evidence with regard to this January 23, 2018 incident as provided in the 119 pages of item 2 of the defendant's fifth amended reciprocal discovery exhibit list. I will not foreclose the state regarding page 68 of the 81 pages. If they're able to find that additional document, we can address any argument at that time as to why that should be included. Anything further, state, before we bring in our jury?
Judge, the defense team has indicated to me that they intend on using demonstrative aids during opening statement. The ones that I have seen include jury instructions that may not be given and may not be given in the way that the court gives, and photographs that could be coming into evidence. I identified at least one that I don't recognize as something they sought to be seeking into evidence, perhaps two. So I believe we should have a discussion about each and every one of those. They should each be marked for the record purposes by letter so that we can refer to them and make a record. I believe it's in the court's discretion, even though I rarely see it exercised in this way in this circuit, to allow the respective parties to refer to actual exhibits during opening statements. I would urge the court not to allow that. They're going to see them soon enough, but particularly with what they are seeking to introduce, given the motion in limine ruling that the court has already issued, that at this point in time, the latest proffer with the defendant's testimony is not amounting to an overt act that will result in a self-defense instruction, that will result in prior instances of violence coming in, that it would be extremely prejudicial, dangerous, and to use Mr. Cacciatore's analogy, very impossible to put that toothpaste back in the tube if we amplify our opening statements, which may or may not come to fruition when we start talking about these past instances and battered spouse syndrome, it would be greatly amplified if they're actually seeing exhibits of the defendant's past injuries that she's attributing to the decedent. So I'm asking for us to discuss that.
Response before we go through each photo.
Judge, yeah, the defense is self-defense. Sarah's going to testify that she was defending herself. We believe the court's going to rule we're entitled to put on a case involving self-defense. And under the instruction for justifiable use of non-deadly force and the justifiable use of deadly force,
I'm not discussing the jury instructions at this time.
there are evidence of prior threats of prior events of violence committed under that instruction, under the self-defense justifiable use.
Here's my concern. Why are we addressing law in opening statement?
Well, I agree with the state attorney. I did blow up a couple of these on the justifiable use of non-deadly force.
That does not answer my question.
I would agree not to use those.
Okay?
The two I'm interested in using and opening is the standard instruction. It is up to you to decide what evidence is reliable. You should use your common sense in deciding which is the best evidence and which evidence should not be relied upon in considering your verdict. You want me to read it out?
No, I can see it, sir.
And then the other one is, a reasonable doubt is not a mere possible doubt, speculative, imaginary, or forced doubt is the standard instruction on reasonable doubt.
What's your position with regard to those two, Mr. J?
Judge, opening statements, we should be discussing what we anticipate to come into the trial, and that's going to be enough of a minefield. It really shouldn't be about the law. We'll both have an opportunity to use the actual jury instructions, which we have not decided upon. We will have the opportunity to use that overhead or any means that we want at the end of the trial during our closings to put up what is actually decided to be the law after the case has been presented. So it's our position that we shouldn't be using demonstrative aids with portions of jury instructions. We're going to have that opportunity to argue how the law applies to the facts at the end, and we will have the correct version. And if the court is following the tendency that I've seen in this circuit recently, we may, in fact, read 3/4 of the jury instructions to them before we even begin our closing remarks. I think it's premature and problematic to be doing that at this time, and it's not the role of opening remarks.
Any other response?
Judge, I've been doing this 35 years. I've had these boards. I've used these boards in opening statements I don't know how many times. I've said that I would waive introducing the one specific to self-defense, but reasonable doubt is an instruction you gave to the jury when we got started, and then this weighing the evidence is a standard jury instruction that applies in every case.
Are those the standard? Is that the language of the standard instruction?
I have not had the opportunity this morning to pull up the Florida Standard Criminal Jury Instructions off the Supreme Court website due to dealing with motions to eliminate, trying to prepare my opening statement, and doing all the things that I should be doing on the eve of openings. But I did notice that I did not believe the reasonable doubt instruction was complete just from memory, and I know that's not the complete weighing the evidence instruction either. It's an entire page of instructions for each of those.
Can I see the reasonable doubt instruction, please? Well, here's the first problem. That's the wrong instruction. Florida Supreme Court revised 3.7 earlier this year. That is not the appropriate definition of reasonable doubt. It is not what was read to the jury during jury selection. 3.7 now reads, proof beyond a reasonable doubt, and it does not mean proof beyond all doubt. A reasonable doubt is not a mere possible, a speculative, imaginary, or forced doubt. Such a doubt must not influence you to return a verdict of not guilty if you have an abiding conviction of guilt. On the other hand, if after carefully considering, comparing, and weighing all the evidence, there is not an abiding conviction of guilt, or if having a conviction, it is one which is not stable, but one which wavers and vacillates, then the charge is not proved beyond every reasonable doubt, and you must find the defendant not guilty because the doubt is reasonable. That does not track the standard jury instruction. For those reasons, I'm not going to allow it.
Judge, I'll have it redone in arguments.
As long as we're still in the process of working through. The 3.7 instruction speaks for itself. I won't preclude you from using enlargements in closing, but for the purposes of opening, because it doesn't track the 3.7 instruction, I'm not going to allow it.
And this is an excerpt from when you...
Give me a moment. That seems to be the standard 3.9 instructions, or at least portions of it. Response?
Again, since it's not all of it, it's misleading. It's highlighting something about the law. When we're just talking about opening remarks, 6 through 10 are optional. We haven't decided which out of the optional instructions 6 through 10 we're going to use in this case because we have not heard the evidence yet. So I just think it's inappropriate to be delving into pieces and portions of jury instructions before we get the evidence. What we should be doing is explaining to the jury what we believe the facts are going to show and the inferences that they can draw from them, and argue the law later.
Last bite at the apple, sir.
Judge, they've got to have some guidance to the law, you know, that in many ways, we do it where we give them the law at the very end, you know, and I understand the reason for that, depending on the evidence that comes in, but there's standard instructions that are going to apply throughout. And this is just giving them an idea of what their role is in considering the credibility of witnesses. I think it's appropriate. It's a brief statement of a standard instruction that comes in on every case.
Let me move to the photographs before I address the 3.9 issue.
I think for the record, we should mark them.
Okay. Do you want them marked? You want them marked by Madam Clerk, correct? Okay, so let's approach with that first photograph, please. Madam Clerk, yes.
record, this is identified as A, Defendant's Exhibit A. For purposes of a demonstrative aid in an opening statement, is a picture of Sarah Boone that was taken by law enforcement on one of the incidents involving arrest. And as you can see, there's a letter right here, which we believe is relevant, admissible.
Okay. Next photo.
This is B. This is Defense Exhibit B, which is a picture of Sarah Boone on the back porch of the townhouse in question with her 2 dogs. Defense Exhibit C is a blow-up of a picture of inside the townhouse showing the sliding glass door as well as the staircase that leads to the master bedroom and the Defense Exhibit D is a picture of the large screen TV with 6 or 7 holes in it from where Jorge Torres hit the TV with a bat directly at Sarah Boone. Defense Exhibit E is a blow-up of injuries to Sarah Boone's left arm from Jorge Torres. Defense Exhibit F is a close-up of the wound to Sarah Boone's leg where Jorge Torres stabbed her with a stapler. Defense Exhibit G is a close-up of Sarah Boone's face that shows where Jorge Torres poked her with a curtain rod. Defense Exhibit H is a photograph, close-up of Sarah Boone after she was kicked in the head by Jorge Torres. Defense Exhibit I is another close-up of Sarah Boone's face after she suffered injuries at the hands of Jorge Torres. All these, I believe, Judge, all these exhibits, except for the first one, A, were in Sarah Boone's phone. The state took custody of the phone. The state had the photographs. The state provided the defense in discovery with these photographs. We intend on introducing these photographs. We don't intend on introducing the blow-ups. We intend on introducing the homicide pages of the photographs, and then using these as demonstrative aid to show the jury during opening and then closing the injuries that Sarah Boone sustained at the hands of Jorge Torres.
Any other further argument with regard to the use of those items pre-marked as A through I in opening statement? Mr. Owens.
Yes, sir, Judge, and I sent you some case law.
When did you send it, sir?
This morning.
I have not received it.
I think, Judge, we're already on bench, so we sent it to the clerk and Jay.
Has the state seen a copy of it?
I'm familiar with the case law. I did receive the email. I'm not sure if it indicated who all was copied on it. A separate one, but I'll check.
Is it just these 2 cases? I've been provided Alsaguer v. State, 326 Southern 3rd, 656, Florida Supreme Court, 2021. Lowe v. State, 259 Southern 3rd, 23, Florida Supreme Court, 2018. Yes, sir.
Judge, the court has discretion to allow demonstrative aids. If you look at one or both of those, there was a state wanted to introduce a dummy they were using in a homicide case, which the court allowed. Other cases have allowed photographs and demonstrative aids to be used in opening statements. In the Alsaguer case, which is the 2021 case. Trial court acted within its discretion in permitting state's use of a map as a demonstrative aid during the guilt phase rebuttal closing argument in a capital murder trial, where evidence visually demonstrated on the map was not without support in the record. That was actually an exhibit that was in the record. The 2018 case, Supreme Court of Florida, again, the trial court acted within its discretion in allowing a demonstrative exhibit. In that case, it was a murder prosecution. Trial court acted within its discretion in allowing the state to use a mannequin in a demonstrative aid in order to show the position of the gun in relation to the victim's body. The mannequin was used to set out the circumstances of the crime and to attempt to establish aggravation. The mannequin was used to demonstrate the location of the gunshot wounds, the angle of the impact against the skin, the incapacitating nature of each gunshot wound. Advising of the trajectories were anatomical, not spatial, and had a small degree of error, where only was slight difference between the victim's size and the mannequin's dimensions. There was nothing to suggest the mannequin was altered to resemble the victim. The court allowed, again, the court's discretion. As you know, we're claiming self-defense, and as part of that instruction, we're entitled to allege prior instances of difficulties and prior acts of violence so that the defendant who asserts self-defense, their state of mind is different from the norm. Take the two instructions we read. Find that Sarah Boone, who because of prior threats or difficulties with Jorge Torres, had reasonable grounds to believe that she was in danger of imminent use of unlawful force at the hands of Jorge Torres, you may consider this fact in determining whether the actions of Sarah Boone were those of a reasonable person. Goes on to say, you find at the time of the alleged second-degree murder, Sarah Boone knew that Jorge Torres had committed an act of acts of violence. You may consider that fact in determining whether Sarah Boone reasonably believed it was necessary for her to use one of them. We have a good faith belief that the exhibits will be introduced into evidence. They're demonstrative aids to aid the jury in understanding the circumstances surrounding that relationship and the actions that Sarah took and the reasonableness of those actions in light of their history.
Thank you. Any response, State?
Yes, sir.
Yes, sir.
Judge, the standard is, it is your discretion, and you will only be reversed if you abuse your discretion in this regard. The state is urging you just flat out, as a matter of principle, to not allow the parties to go into the exhibits during opening statements. They're going to be seeing the actual exhibits in the very, very near future. I mean, we can do this. We can play the videos. We can show gruesome autopsy photographs on the big screen as well during opening statements, but those things are all coming. So we're just asking you first, in general, let's not extend the opening statements in that regard any more than necessary. Now, our specific objections are this. With A, which is beneath everything now, but the bloody ear from the prior incident, I believe that is from a body-worn camera, and I think he indicated as much it was not from her phone. If we get to that point where we know that this piece of evidence is coming in, that would be one thing. But right now, the law of the case is they cannot put on any evidence of prior instances of violence, any reputation evidence regarding the victim, or go into battered spouse syndrome in the evidence until self-defense has been established, and that self-defense must be established by the testimony, and in this particular case, it has to come from the defendant, of an overt act taken by the decedent, which resulted in an imminent threat of great bodily harm or death. And we have had that litigation. We have provided the court the most recent testimony regarding the defendant's most recent statements from the two doctors, and it doesn't exist at this time. So it's one thing for the parties to go into things in opening statements that don't end up coming into evidence. And when the defendant does that, well, under King versus State, the state gets to point out, look, they made these promises in opening statements and they didn't come to fruition. So you need to disregard everything that you heard that was going to happen in trial that didn't. But the problem, particularly for the state side, is we don't get to appeal. So if we go through opening statements and we have the jurors not only exposed to our words about things that may or may not be coming into evidence, but exposed to 1,000 words per picture, if a picture is worth 1,000 words, that amplifies the error. and it's an error the state has no remedy to fix. So we're asking for A, which would absolutely come into evidence. If we get this overt act testimony, which has not occurred yet from the defendant, and certainly this is, A would come in some of the other letters. And there's nothing wrong with them blowing it up like that. In fact, the state has it on their exhibit and will be showing it on the screen as well. There's not, a lot of dispute over whether that will come in if we meet that standard of an imminent act or an overt threat of an imminent act of danger. B, I'm not sure B was on their list of items that they sought to introduce from the phone. We would argue a picture of her with her dogs on her porch doesn't have any relevance. I don't expect that to be coming into trial, so we're objecting on that separate ground. And then returning back to C, D, E, F, G, H, I. State is all aware of those photographs. We are prepared to introduce them ourselves through the digital evidence. There's no hiding those things if we meet the threshold for this sort of evidence coming in.
Could you identify those for me? I'm trying to keep notes contemporaneously.
Yes. C.
It was C through I inclusive?
Yes.
Thank you.
B is the only one that is not a photograph of prior violence. I don't know, it wasn't on their list of things that they sought to introduce, and I don't know what the relevance would be of her just sitting there on her porch with her dogs. But A and then C through I, judge, absolutely at the end of the trial, great. Blow them up, use them as much as you want. But in this particular case, with the rulings that the court has already made about this, based on the state's motion in limine, it is very dangerous to allow them to do this when we are not expecting it to be admitted into evidence based on the current state of the defendant's testimony.
Thank you.
Thank you.
Mr. Owens, if you could address Exhibit B, it was pre-marked as B.
But Judge, you've already ruled that these things come in and open. Remember that part?
No, what I ruled is that you were able to discuss them, address them in opening. Photographs are a totally different kitty.
I said nothing about battered spouse syndrome. I said self-defense. These exhibits come in under self-defense. In arguing these, I've said nothing about battered spouse. I'm talking about self-defense.
I understand.
And prior difficulties, prior acts of violence is a standard instruction.
But the overt act requirement remains. We've reviewed Holland and read it multiple times.
In good faith, with discussions with my client, we believe there's going to be evidence of an overt act, that she was facing imminent threat, and she reacted based on that threat.
Understood. Your response to Exhibit B?
Look at B. Which one's B?
It's her on the back porch with the two dogs.
Judge, not only did he abuse, Jorge Torres abused.
That's not the issue. The issue is that the state represented that it was not part of your exhibit list.
I believe it is part of the exhibit list. We got this from the state. They sent over a bunch of pictures of flowers or paintings that they want to introduce, that they listed as exhibits. I thought for sure we put this on there, but the relevance of it is not only did he abuse Sarah Boone, Jorge Torres, he abused the dogs. And he would threaten to abuse the dogs to control Sarah Boone.
Okay, thank you.
They're checking, Judge.
All right.
On whether they have all this.
The court's prepared to rule at this point in time. Thank you both for your presentations and your argument. The court's had the opportunity to what was pre-marked as A through I inclusive. First, with regard to the portion of the 3.9 instruction, purposes of opening statement is to set the table of what the issues are, what the parties believe the facts and evidence will show. It is not a proper time to be discussing law or elements of law, and that is an element of law that will be instructed to the jury at the end of the case. So the court's going to exercise its discretion for those reasons and prohibit you from using the portion of the 3.9 instruction in opening statement. You could talk about this is a job that you're going to have, but I'm not going to allow you to read portions of the instruction for those reasons at this time. With regard to what was pre-marked as A through I, the Holland case is clear. Before a defendant may introduce evidence of the victim's character, he must first show that there was an overt act by the victim at or about the time of the incident that reasonably indicated a need for self-defense. I understand your good faith belief. I take no position on whether or not you're going to make it or not. That's something that you're going to have to establish. But the concern is that the photographs, some of them are graphic in nature. The lacerations, the sutures, the bruising, facial wounds with bleeding may have such an impact such that the toothpaste cannot be placed back into the tube, assuming that overt act hurdle is not met. And the court, again, takes no position on whether or not you're going to be able to meet it because I haven't heard the evidence and testimony. So court's going to exercise its discretion for those reasons. You can talk about it. You can talk about it that she was a victim. You can talk about some incidences made happen, but I'm not going to allow the photographs at this point in time for those reasons, for your utilization of them in opening statements. Any questions or clarifications with regards to the court's ruling? State.
No, Your Honor.
Defense.
No, sir.
All right, are we prepared to bring in our jury at this time?
Got two other issues.
They've been waiting for an hour and 20 minutes, Counselor.
We intend to play the 2-minute Suitcase video to the jury in opening statement.
State.
Again, I'm asking you to urge your discretion. They're going to hear it in the next 2 days of court. It's within your discretion whether we're going to start using exhibits during opening statement.
What's the other issue, sir?
I need to approach the bench on the
Okay. With regard to the video, I'm not going to allow proposed exhibits to be used in opening statements. What's good for the goose is good for the gander. I'm not going to allow your photographs, I'm not going to allow the state to do anything. You can orally talk about what you believe the evidence and testimony is going to show, but the actual evidence is going to have to be presented here through witnesses or through demonstration and publication after that evidence is admitted. Y'all can approach.
While we approach, can somebody from their team start dismantling these things?
Please, I would appreciate it. Thank you. As for the conclusion of the opening statements, we'll begin with the state's case in chief through witnesses. With that, Mr. J, you may proceed, sir.
Thank you. Ladies and gentlemen, what the evidence in this case is going to show you is that this defendant zipped Jorge Torres shut in a suitcase. She was able to do this because at the time of his death, he only weighed 103 pounds. And she did this with the malicious intent to punish him. And then she went up to sleep and left him to take his final breaths on this earth alone. How many breaths those were, we don't know. The evidence is going to show that it was at least for about 15 minutes, because there's going to be 2 videos that the defendant herself took of this event. The evidence is going to show Jorge Torres is dead because in this defendant's judgment, he deserved it. And out of a conscious disregard for whether he lived or died, you will see and hear these videos. What I expect you will hear from a video that began at 11:12 p.m., 45 seconds, on February 23rd, 2020, in Orange County, Florida, is a suitcase on the ground, face down, with the zippers facing the floor. You will hear Sarah. The defendant will say, "For everything you've done to me." Sarah. "For everything you've done to me." Sarah. "Fuck you." And then the defendant laughs. Sarah. "Fuck you." And the defendant laughs. Sarah. "Stupid." Sarah. "That's my name. Don't wear it out." Sarah. "I can't fucking breathe, baby. Seriously." "Yeah. That's what you do when you choke me." Sarah. 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 The defendant laughs again. Sarah, "I can't breathe, babe." She laughs again. "That's on you." Sarah, "I can't breathe." She laughs again. Unintelligible words. And I would submit the evidence is going to show, because of the intoxication from alcohol, is the next thing she says. Sarah, 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 "I can't breathe, baby." That's what I feel like when you cheat on me. Sarah, "Fuck you." "I can't fucking breathe, Sarah." "You should probably shut the fuck up." Sarah, "Shh," is the last thing you will hear the defendant say to Mr. Torres as he is face down, zipped shut in a suitcase. That, again, began at 11:12:45 and lasts just over 2 minutes. At 11:23 and 3 seconds p.m., there's a second 22-second video, and it's the defendant zooming in on the suitcase. And all you hear during this 22 seconds, after he's been in this suitcase since at least 11:12 p.m., is one more time, Sarah. How did we get to this point where 103-pound Jorge Torres gets put into this suitcase, left to die? Well, the next morning, the defendant wakes up, late morning, perhaps early afternoon, somewhere in this time range, several hours later. And she goes downstairs, and she doesn't see George anywhere, just Torres, and eventually realizes, oh my God, he's in the suitcase. The first thing she does after taking him out, and I believe you will hear a description by the defendant saying, he took his little legs out. At some point she makes that statement. And tries to resuscitate him. Hears gurgling as she presses down on his 103-pound chest. forcing whatever air was trapped in there out and gurgling. And the next thing she does is she doesn't call 911. She calls Brian Boone. Who's Brian Boone? Brian Boone is her ex-husband. They share a child in common. And this date, February 24th, 2020, is a Monday. A normal work day for most people. School day for their child that they share in common. But after they got divorced, the arrangement was every other weekend, no co-parent. And that weekend included Friday, Saturday, Sunday. So it's got 3 scheduled. And then Monday through Tuesdays, their child would be her responsibility. And Wednesdays and Thursdays, their child would be Mr. Brian Boone's responsibility. So February 23rd, 2020 was a Sunday. And now we've led into Monday, 2020. February 24th, 2020. Mr. Boone had been trying actually to contact the defendant a couple times that morning because he just wanted to confirm she was going to get their child after school that day. And there had been a history of reliability issues on that issue on her part. So you will see in the phone record, he calls her and calls her and calls her. And then she finally calls him back instead of calling 911. And being the nice co-parent that he is, he comes over. It's a short drive, 10 minutes. And as she's explaining to him what the heck is going on, he peeks in through the front door of her townhouse, which allows you to view all the way to the back sliding glass door. You're going to see that her kitchen is off to the right, but there's a doorway that you can see all the way through. And on the back side of the kitchen and the breakfast room area, there's tables and stuff. There's also some blue legs sticking out in view. Brian Boone says, check please. You need to call 911. He doesn't set foot into that townhouse. He does wait outside though, being the good co-parent that he has been. So now, after having first called her ex-husband, after having first waited for Brian Boone to come over, the defendant makes the 911 call. What you will not hear are tears. You will not hear sorrow. You will hear a certain level of concern. My boyfriend and I were playing last night. Put him in a suitcase, and we were playing hide and seek kind of thing. I fell asleep. Found him dead in the suitcase this morning. I don't know what happened. He had blood coming out of his mouth. Don't know if it was an aneurysm. Pulled him out of the suitcase, tried to give him CPR. He was in the suitcase and I fell asleep. He's not awake, he's purple, he's not breathing. There's some instructions about how to do CPR given to her, asking about whether an AED is available to shock his heart. It's too late. He's cold, he's stiff, he's purple. We were playing hide and seek. We were playing hide and seek. This is horrible. This is horrific what happened. Like, what happened? We were playing hide and seek last night and I fell asleep. So she mentions that there was blood coming out of his mouth. And his body, like all bodies in suspicious deaths, was taken to the 9th District Medical Examiner's office and autopsy. What the doctor found was what we would expect after being left in a suitcase, crumpled up in the fetal position. He passed from positional asphyxiation, meaning like you're not going to get full breaths when you're crumpled up like an accordion, and environmental suffocation. You don't have to have a plastic bag over your head, tape shut with a full roll of duct tape to seal it off 100% and be worthy of the vacuum of space to environmentally suffocate. It's close enough if you can't get the oxygen and the CO2 coming in and out of your environment. But she also did notice, yeah, he suffered from blunt force trauma on his torso, in his face, his mouth. She'll use words like contusion. We'll help her explain contusions and bruises. She'll use words like hematomas. We'll help her understand for you all that means bleeding under the skin and blood. What you expect from a bruise, that's why they're running blue. But he had all this additional trauma. He had trauma on his fingers as well. So now, the sheriff's office, Orange County Fire Rescue show up, and the defendant interacts with the first patrol officer. You will see and hear that body-worn camera, and it's more of the same as what we heard on the 911 call. Hide and seek, it was good. I fell asleep. I don't know what happened. A few hours later, the detectives from the homicide unit at the Orange County Sheriff's Office approach her and are ready to interview her after doing some initial things, which includes grabbing her cell phone off of a counter that was found by a suitcase by Mr. Torres, and giving it to one of their digital forensic examiners, who we'll hear from later in the trial, Janelle Long. But it's time to give a first interview with the defendant. So they do a first interview with the defendant in one of their unmarked detective patrol cars there on the scene. And the basics of this remain the same, but there's a little more elaboration, as you would expect from trained detectives versus getting the 911 call taken. But the basics of what the defendant tells them is we had wine, we painted, we drew, we did puzzles. The particular wine we had was a Chardonnay from the Woodbridge winery. The bottles, plural, are in the trash. We started about 4 p.m. after Mr. Torres went to the store. Puzzles, art, listening to music, enjoying each other's company. We were literally just enjoying one another's company. The other bottle of wine that was left over from Boone wasn't even half full, so the description she is saying is 1 bottle of wine and plus a fraction of a bottle of wine left over from the night before. Ladies and gentlemen, not all bottles of wine are made the same. Many of us may envision what you would expect at a restaurant. Those are 750s, 750 milliliters of that. Bottles of wine that were recovered from the defendant's trash can were 1.5 liters, so the equivalent of 2 standard bottles of wine. A 1.5 liter bottle of wine is 50 ounces. Given that a standard serving of wine is 5 ounces, you can begin to do the math. And here's receipts. The day before, Saturday, February 22nd, 2020, there is a receipt from Publix for a bottle of Woodbridge wine for $9.74. And then Sunday at 12:17 p.m., there is another receipt for $9.74 for a Woodbridge Chardonnay bottle of wine. And then at about 5:30 in the afternoon on February 23rd, again, there is another receipt for the same bottle of wine for the same price. And those 2 bottles of wine were recovered. They're going to be produced to you in evidence, and you will see that they are, in fact, Magnum bottles of wine. So that's the context that we're dealing with when we hear things like, we only had 1 bottle of wine, and we finished what was left in the bottle of wine from before. Well, ladies and gentlemen, there's 2 1.5 liters that apparently were consumed by a 103-pound man and the defendant, who is in the same weight class. Plus, if you believe that the defendant and the decedent would leave leftover wine from any given day, any additional wine that was remaining from the 1.5 liters from Saturday. Ladies and gentlemen, that's a lot of wine. So in that context, we were just having wine, enjoying each other's company. At one point, we play hide and seek. She says she didn't zip it up all the way. There was enough room, in her words again, there was enough room for his little fingers to get out. We were still having a good time and whatever. And basically, Mr. Torres is stressing out about jobs, his ex-wife, about money, and so they're just doing puzzles and doing things to keep his mind off of it, doing art, playing with the dogs, dancing with the dogs, playing hide and seek. We were always trying to outdo each other where we could find each other the best. When they started playing hide and seek, she went up to the shower and then got tired of hanging out in the shower and came down, and that's when she found him playing around in the suitcase. We both thought it was funny. I'm going to zip you up. 2 little fingers could stick out. And she went upstairs thinking, he'll get out, we're going to have sex and go to sleep and call it a day. It was a good day. She insists that they had wine, but we're not drunk. You will be able to assess that for yourselves when you hear the recording she made. No ill will between us last night. Last argument, maybe last week. Don't really argue. We came home, drink, smoke, did art, listen to music, play with the dogs. We drink what we can afford. We used to be able to afford liquor, but now we can only afford wine. And that's how that day ends with the police. She goes and sleeps and stays at her ex-husband's house the night of February 24th and 25th. What they are doing, and by they I mean the Orange County Sheriff's Office in part, is going through her phone. That's when they discovered the 2 videos that I just described for you. And there's other things in the phone, which I will discuss with you in a little bit. But she's summoned in for another interview, and she sits down and gives another interview on February 25th, now Tuesday. She does describe past instances of violence. You're going to hear about that. She's going to say, Mr. Torres had hit her with a curtain rod about a month ago. Since then, though, we've been good. I've been good. She describes that he comes at her all the time. He comes at me, so it's either I flee or I try to go upstairs and go to sleep. That's usually what it is. I don't know if you talk to Brian, her husband, about any of that, but most of the time I flee and I go over there. There's a discussion about why she stays with him, and you'll hear that for yourself. She will say that she doesn't really want to drink. She just takes an occasional drink. She drinks to placate him, Mr. Torres. She says that you're going to see phone videos of Mr. Torres smashing her TV in the past, like a month earlier. You may see that too. But she doesn't get drunk. When she drinks, she likes being non-compos mentis, her words, not mine, having her wits about herself. Then she gets to the hide and seek again and describes that they've played it 3 times before, but had never zipped one another shut in it before. And they were really just running out of places to hide because it's just a townhome. She does not remember, according to her, she does not remember taking any photos or videos of the night's events. At this point, they ask her, well, would you like to see it? And she says, I can't watch this. I flipped him over, and that's where it was. Guys, this is killing me right now. That's why I flipped it over between the 2 videos. I didn't do anything intentional. Discussion over whether he had enough room to get any of his fingers out from the zipper. My intention was not to leave him there. We both got in there. Both of us were in there. When she went upstairs, my plan was not to, quote, he'll be up here any minute. My plan wasn't to leave him in the suitcase. Why is all this going on? It's the drinking. That's what it is. It's the drinking. I thought he was okay. Guys, that's how we were with each other. Nobody understands our relationship. This whole suitcase thing never happened before, though she described it happening before. I'll never drink alcohol again. She insists that she has no injuries on her, and you don't have to take her word for it because they took photographs of her, and there were no injuries on her. She insists over and over that there was no violence that day. It's like, okay, we're in a good place right now. They ask her about saying fuck you to Mr. Torres. Well, that's just being playful and having a good day. Everybody's having a good day. I didn't touch him, nor did he touch me. Her words. What else is found on her phone? There's a conversation between Mr. Torres' brother, and again, nobody knows who's using these phones at the time text messages are sent in these records that you're going to see. But it's indicated that there's a communication between one of the decedent's brothers and the owner of the phone that was taken that belongs to Ms. Boone. The text from the brother is, yo, my daughter told me what you did, Sarah. I don't want you around any of my daughters or nieces and nephews. And that's Christmas 2019, just under 2 months before this event. She replies, or the person using her device at this time, ugh, your quote-unquote dad hit me in the face. The next text is, hide and seek, I shall. January 13th, there's another heated discussion. She describes it on January 13th in a text to Mo, the brother again. It's a Torres thing. Boo. Sends a picture. Keep the fugly creep out too. It's still fugly. Lose. The brother responds, please do something with yourself, Sarah. God bless you. The defendant's response, and bless you and all of you too. I'll get, in all capitals, rid of him. Then it'll be, in all capitals, better. Ugh. Torres, referring to Mr. Torres, getting rid of. And that's the case. That's what the evidence is going to show. But we, the state of Florida, and the members of the jury in our journey through this case, we're all going to come up to a door that says, danger, keep out, stay away, by court order. And that door says, the defendant's history with the victim. It is a door you shall not enter without permission and invitation. Halloween in like 13 days. Part of the vampire lore is vampires can't come get you in your own house. Well, I participate during this trial. we're going to be invited in to the defendant's past relationship for the previous couple of years with Mr. Torres. And as we come inside this room, at her beckoning, we are going to have things pointed out that she would like us to focus on. And you're going to hear the first night the defendant met the decedent, Mr. Torres, he smashes her phone, punches her. It's the first time in her life she'd ever been punched, I expect the testimony to be. And he made her curl up in a fetal position on her own porch for 4 hours. And she was only able to escape this situation when he fell asleep. I expect that you're going to hear that Mr. Torres is an alcoholic. I expect you may hear his high score on his blood alcohol level was a 342 once when he got treated at the hospital. This is a man who has serious alcohol problems, and I expect you're going to hear about that. Despite that first date, and this is going to tie into some other things that I expect could possibly come in, despite that first date, despite at that point in time of this first date not having a relationship, emotional ties, and the things that come along with a relationship that make it harder to break off a relationship, it's one thing to have a bad first date, it's another thing to end a 25-year marriage. Despite that first date, there's a second and a third. Now, these dates are at bars, and there's nothing wrong with that. But, and it just typically ends up, she's going to tell you, I suspect, or you're going to hear that she said, one way or another. It's one thing or the other. Like, I ask a dude for a cigarette, Mr. Torres flips out, and I'm going to pay the price. Just things like that. You're going to hear and potentially see, yes, there were injuries that the defendant is going to attribute to the victim causing her. Black eyes, cuts in the face, perhaps from the curtain rod incident that was mentioned in the police interview happening about a month before this. Bloody ear, a stab wound in the leg, which is perhaps described as sword fighting, playing around in that way. But nonetheless, I suspect you're going to hear and see a lot about their past history. And at the end, if this occurs, if this comes in, the state is going to have the opportunity to take the lead of the tour in this room, labeled the defendant and the victim's past history. Now, I'm not going to go into that now. If this all comes to fruit, the fruit blooms on the tree during the trial, we'll discuss it at the end where it's more appropriate. But I'm asking you to not rush to judgment until you hear all of the evidence in the case. And then apply whether or not these past instances have anything to do with what happened on February 23rd. Now, like a home inspector, there are experts to come in and kind of help walk everybody through this room labeled the defendant and the victim's past relationship. I suspect there's a chance you may hear from some experts, psychologists and psychiatrists, about battered spouse syndrome. The state is not challenging in any way that battered spouse syndrome exists. It's well recognized, the experts will tell you all about it. Not disputing that at all. But there's some things that we would hope that you pay attention to during all the testimony, if there is any, about this subject matter. One is that it's not actually a recognized diagnosis in the Bible that they use in mental health called DSM-5. Diagnostic Statistical Manual, version 5, and I think it's text revision, something like that. What it is, and what they describe it as, is kind of a component of post-traumatic stress disorder, PTSD. But because it's not actually in the book, it's like a recipe book. It's like our statute books for lawyers. You go into this book and say you have a particular disorder or diagnosis, it'll say, well, all of us agree that it needs these 3 elements, like elements of crime. Some of these elements have to be prevalent for a certain amount of time, so on and so forth. You imagine it's a cookbook. It gives you the recipe for a diagnosis. But because it's not in the cookbook, you may get some disagreement about what it means between experts. It's kind of like grandma's recipe handed down from generation to generation without being right. But what I expect you'll hear is, it's important for people who don't have experience in certain abusive relationships that are violent to understand the control that can be exerted over an intimate partner by the other one, isolation, psychological violence, emotional violence, physical violence, sexual violence, which I suspect will be described for you as well by the defendant, perpetrated on her by the decedent. You'll hear about all this. And what it ties into at the end of the day, after we talked about this during jury selection, is if there is a self-defense instruction read to you, this is to help you understand what an objective and reasonable person in the circumstances would do. Because years ago, we've gotten better as a society, but years ago when this was first being researched, the question would be, well, why don't you leave? And that spouse syndrome and the testimony from the experts help explain those things to people. Well, it's not that easy. You got to look at what's going on in the relationship, with isolation, control, so on and so forth. And that explains why you wouldn't leave. Well, now, but turning to the facts of our case, what you're going to decide the facts are is ordinary, objective, reasonable person in those circumstances taking those actions if you get a self-defense instruction requirement. That's what it's used for. It's not used for explaining the subjective beliefs that one holds. What you will also hear about these things is, just like any other doctor or any expert, like a home inspector. If a home inspector's report was based solely on the person who's trying to sell the house, what they say about the house, great shape. I rewired the entire thing. Brand new JDC pipes. This sucker's good to go. It's highly rated at $600,000. You're not going to take that home inspector's report unless they lift the hood, take the tires, do all the things at the box. I'm careful. The Carfax does. You want an expert to get reliable information. An expert's opinion is only as good as the information that he or she relies on. They will say, yeah, you gotta take into account the credibility of the person who's giving you the story. Even if it's the patient, the client that is saying, all these things happen to her. You gotta find proper information. You gotta check reliability. Particularly in circumstances that we discussed in the case. So another thing that they're going to tell you is, just because there's a bunch of violent nonsense going on between two intimate partners, doesn't mean that spouse syndrome applies. Some people can go home and fight like cats and dogs, and that's just their day, and they get over it, they live their life to fight another day. Their cycle just spins like that. So just because you hear about those things, what the experts will tell you, it doesn't mean that it necessarily applies. If this testimony comes in, I expected Dr. Harper will say that it applies to Ms. Boone. But we'll talk to her about what she relied upon to make that conclusion. We'll talk to her about some other things and take that journey together to get there. But at the end of the day, after you hear all of the evidence in this case, particularly straight from the horse's mouth, the video, where you don't have to rely upon the credibility of anything other than your own two eyes and your own two ears, the state admits that you're going to return a guilty verdict for second-degree murder. What the evidence is going to show is that the defendant killed Mr. Torres because she decided he deserved it. Not because the evidence will show an objective, reasonable person in her circumstances needed. Thank you.
Thank you, Mr. J. Any opening remarks by the defense?
Judge, can we invoke the rule? It has been.
I've already advised the witnesses.
Okay, the rule sequestration will be invoked. Thank you. You may proceed, sir.
Ladies and gentlemen, good morning. Appreciate y'all being here. I was introduced before. My name is James Owens, and I represent Sarah Boone, along with Tony Henderson and Kevin Beck. Now, this is going to be a 7-day trial. Obviously, it's day, Monday, Tuesday, Wednesday. We're not sure, but we're trying to make arrangements for witnesses to find expert witnesses and whatnot, and we'll know more probably at the end of the day when we Monday, so we can plan. But I know your focus is on this case because you took it. Ladies and gentlemen, there is no higher call than to write a will. No higher call than to write a will. And we're going to ask you at the end of the case to write this will. And find Sarah Boone not guilty. That she was justified in the force that she used to defend herself. That force was reasonable under the circumstances that existed between Sarah Boone and George Torres. Sarah Boone and George Torres were down and out, as you can be. Their life centered around alcohol. Both of them suffered from Used to be called alcoholism, now it's called alcohol abuse syndrome. And so day to day, they struggle with the use of alcohol. You can imagine that. It affected their jobs. It affected keeping employment. It affected even getting a job. As codependent as you can be towards each other. And you're going to learn, with all that, was domestic violence. And that Jorge Torres physically abused Sarah Boone. And she suffered from the effects, the psychological effects that one suffers from repeat violence from an intimate partner. They were together over 3 years. And there were several prior incidences of violence. We've got the photographs. There were incidences where police were called who took photographs. So you're going to be able to see the evidence. And we believe the court will instruct you at the end when you're considering self-defense, which we call justifiable use of non-deadly force or justifiable use of deadly force, that you can consider the prior acts, the history of violence, the prior difficulties that the parties had. And considering her set of circumstances that she was faced with in making the decision to use reasonable force under the circumstances. And the most important thing I can tell you here today is keep an open mind. There's two sides to every story. You're going to hear the state's side, them attempting to paint her a certain way, as they've done here today in opening statement. And then you're going to hear another side. And you're going to have to weigh that. All the evidence, the credibility of the witnesses, the photographs, the videotapes, and come to a conclusion. Now let's talk about this day, February 23rd of 2020, the date of this event. This case has been pending for some time. Here we are, October of 2024. I think the evidence is going to show that they had purchased some wine the day before, but they hadn't finished all of that. So it was in the refrigerator. Many times that's how they start their day. At some point, you're going to see a video from Publix, from where they lived. I believe it's Winter Park. But Publix was not too far from their apartment complex. And they took their car, they drove over there. So you're going to see a videotape from Publix of them both going in the store about noon, and they come out with one of these larger bottles of the wine. And then, of course, there's a receipt, and the bottles are in the garbage can. Of course, there obviously is an attraction between the two. And as everybody knows, couples can have great times where things click, everybody gets along, and then we can have episodes of disagreement. And how are those resolved? Really, that's what this is about. How are disagreements resolved? But George was very jealous of Sarah. And you're going to hear the testimony about that. And that he cannot, in certain situations, he can be very charming. But when his level of intoxication gets to a certain level, is when he gets sad, moody, and a lot of times eventually it involved forcible sex with Sarah Boone or actual physical violence against her. They bought the wine. It's a simple life. They don't have much money, but they both like art. They did that for a while. They both like puzzles. They did that for a while. Well, about 5 or so, the wine bottle was gone. And George had said, I want to go get some cigarettes. So there's a convenience store right close by their apartment complex. And Sarah thought he was just going to walk over there and get cigarettes and come back. But no, what he did was he got her keys, he got her debit card, and he went over to the Publix and he got another bottle. And I think that was about 5:30, something like that. And again, there'll be the Publix video showing him going in and going out, and there'll be a receipt for the purchase of that bottle, and then there'll be that bottle will be in the garbage can along with the other bottle. Well, when he comes in with the second bottle, Sarah knows. This is not good. She knows this means he's going to get to another level of intoxication. So Sarah's concerned. So she attempts to placate him, keep him busy, keep him in a good mood. They drink that bottle. Well, she drinks as well. And at some point, they're intoxicated at a high level. As some people do when they're drunk, they get silly. And they decide to play a game of hide and seek. She goes upstairs, their bedroom's upstairs, to the shower and waits for a period of time. And he doesn't come to her. At some point she gets cold, she gets tired. She wants to go see, well, maybe we got it mixed up. Where is he? So she goes downstairs, and they had gotten a suitcase down a week or so ago. It's an old suitcase that they were going to donate to Helping Hands or Goodwill or somebody, and they were putting some items in it. And it's a broken down suitcase. It's a large suitcase. They both weigh about 100 pounds. And they don't eat good. Malnourished to a large degree. But the pull handle is broken off. And they've attached a little paper clip that's got the rubber around it, and that's how they move back and forth. Well, as she comes down the steps, she sees him getting in and settling in the suitcase. So she walks over there, and they see each other, they smile and laugh, and she zips him up. And she zips him up, and they laugh for a while. And they carry on. She sits on the couch, and at some point he says, "I can't breathe." Now, his face is facing the zipper, and she's got 2 or 3 inches that she's opened it. And she doesn't know. They're intoxicated. She doesn't know whether he's just saying that to try to get her to get him out or what. But he's a captive audience. Physically, they're the same size, but he's much stronger than her. If they got in a fist fight, he would win 100 times out of 100. But she's got him down. He claims he can't get up. He has to sit and listen. It's a unique form of physical restraint. And so she lets him have it. Says things she shouldn't say. You'll see the video. It's about 2 minutes long. She videotapes it. She sits on the couch and turns her phone on and videotapes it for about 2 minutes. There's another video that's approximately 11 minutes later. The first video, the suitcase is flipped upside down. The zipper's on the bottom. 11 minutes later, Sarah has flipped it right side up. Again, open for him to get out. And it's only 22 seconds. And you hear George say, "Sarah." And that's it. Now, the key to the case is that 11 minutes. And what happened during that 11 minutes. Okay? That is the key to this case. Sarah Boone will take the stand. She will explain what happened. She will explain why it happened. The evidence will show that she was justified in the action she took to prevent an attack from Jorge Torres, which the law acknowledges that every one of us has a right to invoke, the right of self-defense. You can hear from the medical examiner. She is going to tell you about some bruising on Jorge Torres. Of course, he was in the suitcase a while, deceased, we believe. And that changes things a little bit, as the medical examiner will explain, but there's some bruising. Sarah's going to explain that to you. Why that happened. What were the circumstances surrounding that? Involving that. Her son comes and stays with them from time to time. He has his own room. He has several of his things there, and there's a bat downstairs. The same bat that Jorge Torres used, and there's a video where George is threatening Sarah. And he's swinging the bat at the TV about as hard as he can. And he does it about 6 or 7 times. You'll see it. Sarah's recording it. And it's during an argument. And he's trying to intimidate her. Sarah loved you. You know, you're going to hear why women don't leave. Why women don't leave. And you're going to hear about Sarah Boone and her struggles, her mental health struggles. Sarah had no intent to kill him. The prosecutor mentioned she wanted him to die. Farthest from the truth. She loved the man. She hated the abuse. She couldn't leave him. She tried. She tried kicking him out 6 or 7 times. He kept coming back. She changed the locks. He kept coming back. She didn't have the family. She didn't have the support. She was weak, vulnerable. You're going to hear it all. You've got to take that all into account to try to understand what happened and the circumstances surrounding this tumultuous relationship. Now, you're going to find that Sarah's not perfect. And, you know, she goes, as many of us do when we drink too much, you know, you sleep in. She slept in. 11, 12, 1, somewhere around there. She moseys downstairs looking for George. She thought he was on the computer looking for a job. She looked outside, maybe he's out smoking a cigarette, and she sees the suitcase. She unzips it. She gets him out. He's purple. She tries her best to do some CPR. She freaks out. The only family she's got is her ex-husband, really. She relies on him. As the prosecutor said, a lot of times she'll flee to her ex-husband's house. And where her son is at, Lucas. It's the only thing she knows to do. She was kind of a sheltered daughter when she was younger. She's smart, but she's not worldly. And she calls, Brian, what do I do? He said, I'm coming over. Please come over. He's about 5 minutes away. And she calls him again within a couple of minutes. Yeah, I'm on the way. He gets there. He walks in the foyer and sees his legs. And she called 911. She calls 911 within a minute or two. Detective Rodriguez arrives. You know, we got the body cam now, so it's recording. So you're going to hear Sarah talking. But Sarah's freaking out. Sarah's thinking, and I'm somehow responsible. Eventually, she gives a statement to law enforcement. She gives one to Detective, or Deputy Rodriguez. Of course, she's not the homicide investigator. She just responded. She's the first responder. And you know, they know what to do. They try to assess the situation. They start putting the tape out. And then they call for the homicide investigators to come, which takes a little time. So she gets a statement from Sarah. Eventually, the homicide detectives get a statement from Sarah and one of the unmarked squad cars. And it's recorded. You might hear that. And then the next day, they take Sarah's phone. Sarah gives them the phone, signs the consent to take the phone, and take it to, they have a phone extraction people at the sheriff's department where they can take out all the data, all your phone calls, text messages, photographs, videos, all that. And they find these 2 videos. Sarah's not aware. She doesn't remember making the video. You can imagine. She gives them the phone. Well, she makes no attempts to do anything other than, here's the phone. So they tell her, you're going to get your phone back tomorrow. We'll bring it back to you tomorrow. Well, they end up having a conversation with the female detective, homicide detective, Hobson, is her name, Chelsea Hobson. And they end up, Deputy Hobson was pregnant, or Detective Hobson was pregnant. They end up, hey, we're not going to bring your phone. I'm not feeling good. Pregnant. Can you come to the sheriff's department? Which Sarah Boone was telling you that was what I was going. That's what they told me I was going to the sheriff's department for. Well, instead, it was an interrogation. And they were going to arrest her. They made their mind up on it. And they were going to confront her and try to get her to confess based on the 2 videotapes. And so there's approximately a 2-hour interrogation that was on the 25th in the afternoon when she got there to get her phone. They said, well, you got to come up here. We need to talk to you. And they got her in the room. It's a small room, but it's being videotaped and audiotaped. And it goes on for about 2 hours of them trying to get a confession to murder. And it doesn't happen. But Sarah lies. She's scared. She can tell they're trying to pin her on this, that this was some kind of intentional act, and it was not. So she lies. She's not a lawyer. She doesn't know about self-defense. She doesn't understand she has a lawful right to defend herself. She doesn't understand that she's justified in using the force that she used. She doesn't. I wasn't there to advise her. No lawyer was there. So she lied. And you're going to hear that. So you're going to have to balance that versus her taking a stand and testifying before you. And we simply ask that you look for the evidence of cooperation of her testimony. It's going to be later, probably next week. The judges will tell you in reading instruction on evaluating a witness's credibility, and they'll talk about corroborative evidence, other evidence that's consistent with the testimony that Sarah Boone will give you. So you're going to have to weigh that in her testimony. Now, self-defense, we talked about it in jury selection, usually a gun, some deadly weapon. The suitcase in this case was a physical restraint for a blocking of an attack, but it was unconventional. Self-defense, nonetheless. Now, as I said, the struggles that occurred, many of them involved the police. So you're going to actually hear from some of the police officers. Maybe some body cam footage. You're going to see some photographs that they took of the injuries to Sarah Boone. And some of the videos you may see of her in a very happy, joyful type of thing. Well, number one, she's intoxicated. Number two, she's safe. The police are there. So her attitude is not one of distress. We're here today, full, packed courtroom. Judge Creighton's here, but you're the most important people. Because you've got to decide this case honestly, fairly, and according to the law. And we talked about the 2 biggest principles from the Constitution that apply. In this case, and in every case in which a citizen like Sarah Boone is brought into a courtroom and accused of a crime. The first is, you as a juror must presume or believe that Sarah is innocent. And that belief stays with you throughout the entire trial. Because of that, she doesn't have to prove anything. That's why the state went first in jury selection. That's why the state went first today. That's why the state will go first putting on their case. They have the burden of proof, and it's the highest burden we recognize in any type of litigation in this country. Proof beyond and to the exclusion of every reasonable doubt. You are going to have doubts about this case. But the most important thing is not to rush to judgment, to keep an open mind, and understand there's 2 sides to this case. There's their side, and there's our side. So you can't form any fixed opinions early on. That's hard to do, as Mr. Henderson said in jury selection. That's extremely hard to do. Now, you're going to hear some testimony. It's been mentioned of experts. Battered women's experiences affect her perception of imminent danger. Battered women's experiences affect her perception of imminent danger. Victims of repeat violence may fear death in a situation others would not. After hearing both sides of this case, we're confident you're going to have a reasonable doubt. And we're going to ask you to follow the law and do justice in this case. And find Sarah Boone not guilty, because it's the right thing to do. Thank you.
Thank you, sir. Can the parties approach for a moment?